Good evening. So once again, for the participants, the general guidelines, please keep your videos on to make it a very interactive session. Second, keep yourself muted during the session. You can unmute and can ask questions to the speaker during the question and answers round. Third, if the speaker allows you to ask the question in between, you can do it, but it's up to the discretion of the speaker. With the due permission of the speakers, I will proceed. A very good evening to everyone present here. I'm Soumya Shukla, today's moderator of the session. And on behalf of the entire Amikus Qriae team, I welcome you all for the one-day workshop on decoding the three new criminal laws, that is Bharatiya Nyaya Sanhita, the Bharatiya Nagrik Suraksha Sanhita, and the Bharatiya Saksh Adhiniyam. Now, I would extend my gratitude to the esteemed speakers we have with us today for taking out time from their busy schedule and joining with us for this intellectual session. Without any further ado, I would take this opportunity to introduce the platform of Amikus Qriae. The Amikus Qriae is the brainchild of several legal luminaries and eminent personalities across the country and the globe. The Amikus Qriae is a dream online platform which aims at proliferating legal knowledge and providing an ingenious understanding with cognizance of various fields of law to make sure that legal knowledge and experience penetrates to every nook and corner of the ever-growing legal fraternity. Through ambitious and studious legal brains across the country, the Amikus Qriae aims to provide valuable contributions to contemporary legal issues, along with development in the omnipresent field of law to the masses. We are also registered under the Indian Partnership Act 1932 and the Ministry of MSME, Government of India. The Amikus Qriae is presently the 8th largest legal website in India. We are connected to more than 20,000 law students from across 80 plus law schools in India. Moving on one by one, it's my absolute pleasure and honor to introduce our first speaker for the day, Prachi Pratap ma'am, who will illuminate Bharatiya Nyaya Sanhita. Ma'am is a seasoned advocate with over 10 years of experience in representing clients in the Supreme Court of India, High Courts, and various tribunals like National Green Tribunals, National Company Law Appellate Tribunal, and law firms. She is an advocate on record with the Supreme Court of India, which enables her to file and argue cases in the apex court. She also represents NRI clients and matters in US, UK, Ireland, Australia through law firm association. As a partner at Pratap & Co., a full-time service law firm, she handles a wide range of legal matters, including civil, criminal, property, matrimonial, IBC, company, and service matters. She is also a 4-time TEDx speaker and a recipient of the Forbes Legal Prover List 2021, which recognizes the top 100 legal professionals in India. Prachi ma'am is passionate about spreading legal awareness and promoting gender equity in the legal profession and society. Thank you so much for joining with us today. We warmly welcome you, ma'am. I definitely would not want to keep ma'am or participants waiting for longer. Before I hand over to you, ma'am, I wish all the participants a very best of luck and hope that we have an exciting session. Over to you, ma'am.
Thank you so much, Soumya, for the lovely introduction. I'm so happy to see Dr. Pandy and Vishavjeet here. And just a quick correction, I'm not an advocate on record. My sister is an advocate on record, Pratap, and our law firm is an advocate on record, but I'm not an advocate on record and don't have taking the exam either. One in family is more than enough. So now we'll just start with the criminal laws. I'll just discuss in brief. I have around 20 minutes, right, Soumya?
Yes, ma'am.
Perfect. So we'll have a cursory look at Bharatiya Nyaya Sanhita. We'll look mostly focus on the changes that have happened compared to IPC instead of dwelling in details about each and every aspect of it to give a nice cursory overview of what the changes are. So the first thing that comes is that earlier in IPC, there were 511 sections, but now under the Sanhita, there are only 358 sections. So the consolidation has been remarkable because it helps, it has structured what had happened that earlier the colonial law, so to say, was more scattered. Every time changes would be incorporated, they were scattered. Now under the BNS, they have tried to structure it more, and the new chapter on offenses against women and children have been added, which is very pertinent because they have accepted. See, the issue with colonial law was it was not just focused on India, it was more of a general law that was focused on all the colonies that were there. So it was not that there were laws that was all the laws were 100% India centric. They were not. So now that we have more offenses against women and child, included in a chapter itself, that comes to show that it has accepted that India as a society, as in our cultural fiber, we have a certain specific offenses that happen in India against women and children, and we have acknowledged that women and children are suffering, which was not the case earlier. We had a lot of parallel laws that were helping women, but now including a chapter kind of empowers the causes of women and child. So just a quick look at what has been included would be, there were sections that related to sexual offenses were there, 63 to 73. Now they have been consolidated amongst 375 to 376 of they have been included in 63 to 73. They were 375 to 376 in the IPC. So criminal force of assault against women, they have included it 74 to 79. That was 354 to, and then it was 509 in IPC. So on and so forth. They have tried to make it more streamlined. Then just have a look at chapter 5 of what I'm talking about, women and child, because this is one of the major changes that have that is visible in the new Bharatiya Nyaya Sanhita. So I won't take much time, but I'll just focus on what are the basic things that have happened. Is it has been made, offenses against women have been made gender neutral in relation to perpetrator. So earlier it was, say, you're talking about voyeurism. That was if a man is engaged in that activity. Now it has become gender neutral. So it could be a man or a woman. That kind of helps, because there were many cases where, falsely a person was able to get out of the case, because they would say that the man wasn't doing it, there was some woman involved in it. So now making it gender neutral gives more right to women to go ahead and file cases and to, get justice in these matters. So there's been modification in the age of marriage requirement. The age of consent for exception raised to ensure that wife is not below 18 years of age, which was earlier 15 in IPC. Has consolidated, the BNSS consolidated punishment for rape for women under 12 and 16 into a single section, streamlining the legal framework. This is under section 65. So the laws concerning rape have not been made gender neutral. Not all offenses have been made gender neutral, that is to be noted, but some of the sections have been made gender neutral. Rape, however, is not amongst those. So only a female can be a victim and a male can be a perpetrator as far as rape is concerned. And transgenders are not defined in this. I mean, transgenders have been included as a definition under the new criminal laws, but as far as rape is concerned, they are not included in it. So, these are the aspects that we know that eventually, maybe when there are more cases that go into the Honorable Supreme Court in the next 10 years, because as we know, a law to be it's in a trial phase for 10 years. That is when we understand how it is actually being used and what changes are going to come. So the first 10 years of a law, of a new act, a new law, is an infanticide stage and an adjustment stage, both for the society and for the law to, get to terms with each other and to adjust to the changes as per the needs of the society. So the inclusion of death penalty for gang rapes has been there, which involves females under the age of 18. And it also highlights the severity of these offenses, because it was not the case earlier, but we must understand that this is a product of all the issue that happened post Nirbhaya case. As we see that BNS is actually a result of a lot of social activism that existed in the last couple of decades. A lot of those points have been eventually included. So a new offense that has been introduced is section 69, which talks about sexual intercourse by employing deceitful means. So this was not the case earlier in IPC. Here, what they have done is, see, there were a lot of cases where there would be, somebody would say that they will falsely be in a relationship, saying that they will marry the person. But here, they have also included that if there is, a person's promises to give a lady a job, that will also be under section 69. So pehle we would come across cases where there was just extramarital affairs were there, that, oh, this person is going to marry and they were in a relationship. Now they have also accepted that a lot of women are duped by false promises of getting a job or a favor at work. So those are also included under section 69, which is, I personally feel it's a game changer because it is going to deter people from involving into such acts. And that is what is mostly seen in BNS. If you come across punishments which were not there earlier have been introduced, the duration of punishment has been increased. All these will deter people from committing the crime, which is basically the goal of any law. It is not just the punishment, but it is also to correct the society from not engaging into immoral activities. Anyhow, so next is changes in trafficking. So again, trafficking has become gender neutral, which was not the case earlier. Voyeurism, I have already discussed section 76, where both men and women will be the perpetrator. And then whenever we talk about a child being engaged into, say, a job or or any factory or any organization, a child is engaged. Just a moment. So so if the act of hiring, employing, or engaging a child to commit an offense is made punishable under the offense, which will be section 95. This was not the case earlier. So and the minimum sentence has been 7 years, which is extendable up to 10 years. So when there is a consequence which is bigger, a punishment which is bigger, the punitive fear makes people to avoid doing the act. I'm not saying that it will 100% happen, as we have seen many, many times in cases related to rapes, but we are expecting that slowly and surely the society will change. Section 366A of IPC was related to procuration of minor girl. Now this, under the age of 18 years. Now this has been included in section 96 of BNS, and this will be procuration of any child below the age of 18. So this is become gender neutral, and we must admit the fact that not only in India are children under 18 in the risk factor of being trafficked, but it is a global worry which is existing, and it is a very important aspect of BNS to make trafficking gender neutral. Personally, as a mother, I find it really welcoming change in the legislation. So also employment of children for committing offenses. So what has happened is that if a child is committing an offense, and the person who has employed the child to commit the offense, the punishment has been increased to imprisonment of not less than 3 years, but which may extend to 10 years and fine. And if the minor so this is just, if you're trafficking, this would be, but if the minor ends up committing the offense, then the punishment for the offense would be on the person who's trafficked, as if the person has committed the offense themselves. So you need to understand that if you're engaging a minor to say something as simple as an organized crime syndicate, you're engaging a minor. So the onus of burden or the punishment gets to the person who is engaging. I can say to you, recently we came across a judgment in a school shooting case where the onus of shooting by the minor was the punitive part of the punishment went also to the parents. So the people who are engaging are also equally responsible, but here it is held that that person is responsible and not the minor. This is a major game changer. And here, when we are talking about these offenses, we are also talking about pornography or such other exploitative practices where minors are engaged by people, by organized crime syndicates, so to say. Kidnapping was had age limits. Male was under 16 and female was under 18. Now this has become any child, and also includes a person of unsound mind. So being taken away from the lawful guardian. So making it again gender neutral and keeping the age same, it kind of helps them to bring forth a uniformity amongst laws, because the discrepancies that we had earlier would make cases more difficult for when they came for trying, because a lot of time it would be like maybe the child gave us consent, so now they have put a blanket age and it has been made more watertight. So the next would be offenses against property. So the section 314 is there, which talks about dishonest misappropriation of property. So here again, what has happened is not much has changed, other than that they have put a punishment of not less than 6 months, but which may extend to 2 years. So this was not the case earlier. As I said, this will deter a person from committing the crime, because earlier when there was no punitive actions given in the law, people would had no apprehensions about committing the crime. But now that they have prescribed a punitive action, they are going to have apprehensions, or at least that is the aim. Criminal breach of trust. Again, it was there earlier, but it has streamlined the legal framework and it has enhanced the punishment to imprisonment up to 5 years. Now, this again makes a person be afraid of committing the crime. I know these are not major crimes. In most of the time, you will come up them under petty, but the apprehension will deter people. Cheating is under Section 318. The BNS consolidates various forms of cheating and increases the punishment to imprisonment up to 3 years. Again, stronger legal deterrence against fraudulent activities have been included so that it protects individuals from financial exploitation. Because we do come across lots and lots of cheating cases, and not just the general cheating cases that we were coming across, but I'll come into talking about cybercrime, where a lot of cheating is happening. So offense related to snatching has been included in 304 of BNS. That comes again offenses against property. So snatching will be a sudden theft, in a sudden, forcible manner, quick and forcible manner. The reason I'm mentioning snatching in a sudden, forcible manner is because snatching is again included under petty organized crime. So the punishment for both of them is different. However, we need to know which one it will be. So offenses against human body, culpable homicide, the imprisonment is 5 years for culpable homicide not amounting to murder, and maximum may be 10 years. Causing death by negligence. Again, there is stricter punishment, which will be, it will be, anybody who has been reckless and causes death by negligence, again, it will be up to 5 years. Maximum punishment was earlier 2 to 5 years, but now it will be 5 years. Medical practitioners, earlier we were thinking that medical practitioners will be out of the bill, but they are still included in it. Any death by medical negligence will again call for punishment up to 2 years. Terrorism. Now, Terrorist Act has been included for the first time in a general statute. It was never the case earlier. Terrorist acts were always under UAPA. So they have included it here under offenses against human body. It is the most important aspect of it is that if Terrorist Act is here also and it's also under UAPA, so which one will be valid? Because you have to figure out under which of the two acts will it be booked. So we always know that when there's a specific law and a general statute, the specific law will have the precedence. So UAPA will have the precedence. However, if there is Terrorist Act and that has to be booked under BNS, they have given a condition which will be that it has to be an officer not below the rank of Superintendent of Police who will decide whether the case will be registered under BNS or UAPA. So wherever overlaps are happening, they have so far they given certain, certain guidelines. But as a general principle, we know that the special acts are going to have the precedence. Mob lynching has been included, and this is again remarkable because we know that there were many, many cases of mob lynching in the past few years. We have come across, especially the past 1 decade. But here the grounds include race, caste, sex, community, place of birth, language, personal belief, and any other similar ground. It is important to note that religion has not been mentioned in these definitions, which is in, as you would say, keeps you in accordance with the preamble. So again, offense related to committing suicide. So suicide is no longer a crime. It was earlier a crime, but now under Section 108, abetment to suicide is a crime. Now, this puts the law in accordance with Mental Health Care Act. We would come across a lot of cases where under IPC, we are saying that suicide, the person who is committing suicide is a crime, he has committed a crime. However, under Mental Health Care Act, it is not a crime. So now both are on the same page. Under BNS, abetment is a crime, and so is the case with under Mental Health Care Act. However, Section 226 is the exception, where it says that a person who is trying to commit suicide, in order to stop a public servant from discharging their duty, तो ऐसे बहुत से cases होते हैं जैसे आप सुनेंगे कि आत्मदाह करना कोई चाह रहा है, तो in those cases where you're trying to blackmail a public servant from doing their duty, in those cases suicide is going to be a crime. So Next would be abetment outside India. So we notice that Section 48 has been included for this first time in BNS, where if a person is plotting commission of a crime in India, the mastermind is sitting outside, that person will be triable in India. So this is for the first time that we are expanding the territorial jurisdiction to anybody who's trying to commit a crime, or and these are not just restricted to the terrorist act. You could also say with the inclusion of cybercrime, this will be very helpful, because we notice under PMLA and how bitcoins and cryptocurrency are all working together. They're in harmony as far as PMLA is concerned, and also bitcoins and cryptocurrency are funding terrorist acts. So a person who's outside will be triable in India. Earlier, we would had to look at certain acts that had extraterritorial jurisdiction, and you would always go into the initial sections 2 and section 1 of the of any act, pick it up and see what would be the territorial jurisdiction of that act. Like whenever there was drugs, we would look into NDPS. Now, there's also organized crime, as I mentioned, NDPS, which had extraterritorial jurisdiction for a reason. There's a very nice judgment, Jiten Panchal, one which talks about extraterritorial jurisdiction of NDPS when IPC did not have the same. So under organized crime, I would quickly read what has been included is kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offenses, cyber crimes, trafficking of persons, drugs, weapons, and illicit goods of services, human trafficking, prostitution. So the reason I'm saying it is because, see, they have included drugs in it, and this is part of organized crime, and Section 48 talks about extraterritorial jurisdiction. So when they have talked about organized crime and syndicate, and there's Section 48, eventually we are going to see, I'm not saying now, but after a year or 2 years or 5 years, you're going to come across cases where Section 111 and Section 48 of BNS are going to come into harmony, and how the cases are going to be developed based on these important sections. It's the first time that economic offenses and cybercrime have been included in this general statute. So including economic offense has been good, because again, under syndicates and organized crime, because earlier it was just PMLA where we would go for economic offense, but now they have given some power over here to better execute the law, because PMLA has its own restrictions that we always come across. Again, cybercrime has just been included as a definition. It is not defined, just been included as a word. It is not defined, because we know that the ambit of cybercrime is going to keep increasing in the next 1 decade. So this is a very good part of it. Now, economic offense will also include, they have written that it will include hawala transactions. So you see, this is where the wordplay comes into play, and the beauty of the act comes into play, that it is, I know a lot of people offer criticism for the act, but there is also a certain visionary aspect of the act that we cannot ignore at this point. Sedition is no more an offense. However, BNS has included Section 152, where the words have changed, which talks about integrity of the nation, which talks about, certain other threats which are there. And it also talks about, publishing via electronic medium. So these anything which is related to criminal conspiracy. So these are important aspects that we notice. Of course, sedition was important, because we came across, there was a very famous case of sedition, that was Mr. Vinod Dua, late Mr. Vinod Dua. There were charges against him of sedition, and they would constantly, like every day we would come across during COVID time, he had a new FIR filed somewhere in Himachal, somewhere in UP, somewhere in Delhi. So then the court gave him relief eventually, and that is one of the leading judgments where he was given relief. However, sedition to be removed was an extremely important part, because we are not a colonial era. Of course, they have reworded it, keeping in mind the basic spirit of the Constitution. And that is definitely, I know people are saying that it has not changed, but it is very important to keep it in order to keep the Union of India intact. So I have already discussed Terrorist Act. I'm just going to, because I know I don't want to take too much time. I've got 4 minutes left. So I'm just going to quickly talk about public tranquility. Offenses against public tranquility have been included, which is Section 197(1)(b), which criminalizes the act of making or publishing false or misleading information which jeopardizes the sovereignty, unity, and integrity and security of India. This is extremely important, because we have come across in the last 5 years a lot of such cases where false information has been spread. So if you reflect at it, you will see how a lot of sections have interconnected and are visionary, keeping in mind all the crimes that are happening in the last 5 years, where we are, sometimes we are falling back upon IT Act to get some to resolve an issue. Sometimes we are falling back upon some other precedents where there is no legislative changes, but there are judgments that lead us. So those have been streamlined here. Again, penalizing cybercrimes and false information I've already discussed under Section 111 and Section 197. This will, of course, result into there will be recalibration of user agreements, terms and conditions, and the guidelines of social media platforms, because the new laws have to be incorporated in it. But of course, we are not going to see that, because we always just hit the agree to all terms and conditions button. But if somebody goes into the fine lines, we will realize that they have recalibrated it, and what we are agreeing to it is greater now with the social media companies as opposed to what we had earlier. So I'm almost done now. So these are the basic significant changes that have happened in BNS. Of course, it is going to change the criminal legal landscape, because justice will be delivered more efficiently. So we hope, because I'm not saying that it is going to expedite the judicial system, but you have more written watertight compartments for various offenses and the punitive actions. It is more transparent and more accessible for us to understand what the changes are. It is in sync with what are the people's need and in line with the demands of today's world. However, implementation part will definitely take another 5 years to 10 years for us to totally be in harmony with it. But overall, personally, I feel it is good, especially as far as rights related to women and children are concerned, and as far as cyber crimes are concerned, because eventually cybercrime is going to be a big part of future court cases that we are going to come across. Thank you.
Thank you so much, ma'am, for the enlightening and inspiring presentation. Your insights and dedication to the legal profession are truly commendable. And now, moving forward, now it's my absolute pleasure to introduce our next speaker, Advocate Vishavjeet Chaudhary, sir. Sir holds a degree in Masters of Laws from University of Cambridge and is also a dual tenant at a London-based chamber. He has an extensive experience of appearing before various tribunals and courts. He has also been a visiting professor at the prestigious National Law School of India, University, Bangalore. He has been widely published in academic and media publications. Other than that, Vishavjeet sir is very passionate about pro bono and making law accessible. He is a keen traveler and fond of equestrian sports. Sir is here with us today to enlighten us more on Bharatiya Nagrik Suraksha Sanhita. We are immensely grateful for your presence today, sir. It is with great respect I now invite you to address, sir.
Thanks very much, Soumya. Can you all hear me fine?
Yes, sir. Audible, sir.
Yes, sir.
Great. Thanks very much for welcoming me, Soumya. Very kind words of you. And I have to say that this is an absolute pleasure to be with luminaries like Professor Pandy and Prachi, Pratap, because I think, they say that it's good to be a learner always. And I think one of the first things that I'll start with is that if you're a lawyer, you're really a student for life. I think every day in our lives, and I think Ms. Pratap will correct me if I'm wrong, but every day in our lives we're learning something new, and sometimes it hits you in the face. Other times it comforts you, thinking you knew what was going to hit you in the face. So it's really good to be here amongst all of you, and it's an absolute pleasure and an honor. I'm going to keep it slightly simple for a number of reasons. The first one being that I do want to keep it slightly interactive. Is that okay, Soumya, with your permission, if I can keep it slightly interactive? I promise I'll stick to my 20 minutes.
So you don't need my permission? Yes, I absolutely, sir. It would be best for us, it will be interactive. Perfect,
great. So can you all help me with when was CRPC, when did it come into force? This is really a trick question that a lot of people, and I don't know how many of you are lawyers, but if you are lawyers, you might have sat something called the All India Bar Examination. And there's a question that I've been seeing coming in it for the last 5 years at least, if not longer. So can somebody help me with what date did CRPC come into force? You can either type it in the chat function or just shout. Okay, I think Meenakshi's hands up. Yes, Meenakshi, please go ahead.
Sir, 1st of April 1974.
Excellent. 1974. Well, I'm already very impressed because most people say 1973. So it's good to know that you all know it was 74, which was a long time ago, right? I mean, it was about almost 4 decades ago. But when did the IPC and the Evidence Act come into force? Longer than that, right? So what I'm getting at here is that the IPC and the Evidence Act, they really needed updating. 1860, absolutely long time ago. So they really needed updating, which means that my task is slightly easier than Ms. Pratap and Professor Pandey's, because as far as CRPC is concerned, or BNSS, as we now call it, is concerned, the amendments are not particularly, they're not as detailed, and the differences are very minor, but there are some crucial differences. I have picked out about 10 differences. There might be 9, but we'll find out 9 to 10 differences. And I'm just going to go through them very quickly. In case you have any questions, just type it in the chat function or raise your hands and I'll be happy to deal with that right away. I'm going in no particular order. I'm not going by section wise. I'm just going by the differences in terms of the way the criminal justice system progresses. The first difference that I feel is one of first information reports. First information report earlier, so there are 2 major differences as far as FIRs are concerned. FIRs earlier dealt with CRPC, and the idea was that if you went to a police officer and you gave them information that disclosed a serious offense, they were obliged to register your FIR in most cases. Can somebody tell me what case was this? Something starting with an L, maybe?
Lalita Kumari.
Excellent. Thanks very much. So, absolutely, Lalita Kumari, right? That mandated that if an offense is disclosed, that is a serious offense, you must register an FIR. Now, BNSS changes it in 2 aspects. The first one is that for offenses which are less than 7 years, it allows the police officer to carry out an investigation. Earlier, the investigation was limited to the principles of whether the offense is cognizable or non-cognizable. Now there has been discretion which has been given to the police officer, which allows them to go into broader query and actually not register FIRs in some cases where they find it not fit. So I think that's a very crucial difference that we have. It's going to have both sides to it and both aspects to it. Depends on whether I put my defense counsel hat on or whether I put my prosecutor hat on, right? So it has different feelings from both those quarters. The second difference that has come in terms of FIRs is something that has been happening for a number of years, and it was limited to sexual offenses. But I think this is a great move in the right direction, which is the concept of zero FIRs, which means that you do not necessarily need to be in the jurisdiction where the FIR is being registered. You can be elsewhere and still register the FIR despite not being in the jurisdiction where you want to be. And this goes with the general theme, and one of the most important things in BNSS is that it's really bringing in technology, and technology is really at the center stage of how we are dealing with crime. Okay, so that's one of the most important differences that we've got as far as FIRs are concerned. The second difference is some courts have been abolished. For instance, metropolitan courts have been abolished. Some judges have been abolished. I think third class has been abolished. But these are all more administrative differences. And in practice, they were not particularly some things that we were bothered with. The other difference, the third difference that I'll come to, is that video graphic evidence of any proceeds have to be now made. So if there is a search and seizure, the police officer or the investigating officer or whoever is doing it will be mandated to carry out search and seizure under video recording. Okay. Earlier there used to be, of course, the provisions of Panchnama and some witnesses being there still. They existed, but now it has to be on video so that it is being properly seen and it can be properly assessed. In fact, only yesterday I was at a session where we were talking about this particular aspect of CRPC. And one of the things that comes out in particular for this section is that it allows for a fairer kind of investigation, because if everything's on video, the risk of things being planted or the risk of evidence being manipulated with is really, really minimized. Okay. The fourth difference that I have seen is in terms of the custody. So this was the formerly known 167 of the CRPC. The ways in which custody was handled has changed. So now police custody can be extended to beyond what it earlier was allowed. The fifth difference is that handcuffs are now allowed. There was a Supreme Court judgment which said that handcuffs should not be used, but now it says that handcuffs in cases where they need to be used can indeed be allowed. Now, whether it will be tested or not, we don't know, but that is where we are in terms of the changes. The other change is that timelines have been provided for cases. It has been said that there are going to be only 2 adjournments. Let's see how much we stick to those. 2 adjournments and trials are expected to be running on a day-to-day basis, and they should be concluded in 45 or 60 days, depending on whether it's a serious offense or not. So that's a very, very significant move in the right direction, because justice delays are one of the main reasons why the criminal justice system is really, really buckling under pressure. Then there is provisions of bail. It has been slightly made stronger to not get bail, because the idea is that people who have committed crimes do not get away with them easily. And related to this is also the hearings that will happen online. So now you can be appearing online, the accused can be examined online, and evidence can be taken using video transmitted measures, which again seems to be in the right direction. There was some concerns about it in terms of where these videos can be done, because can a police officer take a confession? Can a police officer take a confession? Anybody in the chat box? Simple yes or no.
Yes, sir, but that confession will not be binding in the court.
Right. But and which section was this in the CRPC?
Sir, it was section 24 or 25.
Section 20.
You got the basic principle right, but not the section. Anybody who can help me with the section?
164.
164, which said that you cannot, a police officer was expressly, the confession could not be used in a trial, and a confession can only be used if it was given to whom? Who could you give a confession to if not a police officer? Magistrate, right? So only a magistrate could be the one taking the confession. This was 164. Now this remains unchanged, but there was a concern that if you can take confessions, or if you can take evidence, or if you can speak to the accused online, then what happens if the accused is in the police custody, but the confession is being given to the magistrate? So by virtue of that, it can be contaminated. That has been changed to now reflect that it cannot be done in that way. So there's a latest notification that says that it can only be in terms of the confession being given to the magistrate in a designated area without any police interference. So that fear has been made very, very clear. Then finally, arrest of people above the age of 60 if they've committed an offense which is less than 3 years, and women and other parties has now been brought down, has now been almost stopped. So they say that if you don't need to arrest them, you don't, if it's a not serious offense, and if the person is aged or if the person is a woman, then you do not affect arrest in that particular way. Now, these are the sort of 10 differences which I think are between CRPC and BNSS. But I want to go a bit deeper into the theory of it, and I really want to talk about what are your feelings about it, because I think one of the feelings is that, of course, we'll have to unlearn and relearn. But as I said, as far as BNSS is concerned, it's not really something that there has to be a lot of work done on it, because it remains largely similar to what the previous provisions were. But in terms of the new provisions and in terms of how we're going to use it, one of the concerns that has been flagged is that if an offense was committed before the 1st of July, whether do we apply this or whether we apply the CRPC provisions. If CRPC provisions are applied, and if the accused comes forward and says, I actually want the BNSS provisions to be applied, how are the courts going to deal with that, right? Are you going to apply both the provisions, or are you going to choose one over the other? And if you choose one over the other, then are you going to use IPC, or are you going to use the new version of the IPC? Right, so these sort of things, I think there are some judgments to this effect, but really nothing that is too clear, and it remains a sort of gray area, which we are still working our ways out as far as practice is concerned, whether we advise on the old laws, whether we advise on the new laws, or whether we advise on a mixture of the two, because there is that gray area for sure. The second thing that has also come in terms of this particular law is looking at who is at the basic center of it. Who do the laws speak to? Who are the laws protecting? It seems like the focus has been changed slightly, because this has become or purported to become a very, very citizen-friendly law. And I think one of the things which was mentioned when these were coming into force was to make them non-colonial, right? So what I want you to all do and all to think about is, number one, what do we mean by colonial, right? Have your own definitions. Number two, think about how the old laws were colonial. And then number three, think about whether the old colonial laws have now actually been replaced, because that's really the test for these laws. Of course, there won't be any easy answers, and we won't know for at least some time whether we've been successfully able to decolonize the laws, but that's definitely something that we should be thinking about. So that's kind of your homework. What I also want you to do is to actually read the new act that need help with. For instance, I'm just going to give you one example, and I don't know if you've got the act in front of you or not. If you don't, I would strongly suggest that you get one. May I suggest that you also get one which is the latest version, because I've seen many people, there have been amendments, right, since the bill came and when it was passed, and then there have been some amendments, etc. So make sure you have the latest one, because it is otherwise easy to get confused. So I'm going to leave you with two sections. One is 173. If somebody online can help me read out 173. Anyone?
It is regarding the cognizable offences, sir.
That's right. That's right.
Yeah.
So what does it say about them? It says something very interesting.
It deals about the filing the zero FIR.
Correct. So I'm really talking about 173 subsection 2. And I'll just read it out to you. It says, basically saying information relating to commission of cognizable offense, irrespective of the areas where the offense is committed, which is talking about zero FIR, may be given orally or by electronic communication to an officer in charge of police station. And if given, now I'm reading 2, by electronic communication, it shall be taken on record by him on being signed within 3 days by the person giving it, and the substance thereof shall be entered into a book to be kept by such officer in such form as the state government may by rules prescribe, so and so and so. So now you look at it, it not only asks you to put that FIR, but it also asks you to get it signed within 3 days, right? Now, how this is going to be operational, it'll be quite interesting to see, because the infrastructure as we speak is being built, right? Only 2 days ago, I learned that each state has notified their officers how to do this. Each state has told them how is it that you do it, because at the end of the day, law remains a state subject largely. So it will be interesting to see how this is dealt with. Then if you go to section 20, which is another interesting section about the Directorate of Prosecution, it says in section 7, the powers and functions of the Director of Prosecution shall be to monitor cases in which offences are punishable for 10 years or more, or with life imprisonment, or with death, so on and so forth. And then section 8, immediately after that, says the powers and functions of the Deputy Director of Prosecution shall be to examine and scrutinize police report and monitor the cases in which offences are punishable for 7 years or more. Now you see that actually it seems that the Deputy Director of Prosecution has been given a greater function than the Director of Prosecution. Now, to make matters even more interesting, section 10 then says, notwithstanding anything contained in the subsection 7, 8, and 9, the Director, Deputy Director, or Assistant Director of Prosecution shall have the power to deal with and be responsible for all proceedings under this Sanhita. Now that leaves us in a very interesting space, because which section is it that we are in particular looking at? Are all of them with the same powers, or does one have the power over the other? If that's, then houses the deputy and not the director. So what I request you to all do is to start from page 1 and go all the way to the last section and see if you find any sort of things which are anomalies or which are problems. And a final jurisprudential and from practice, I think law has two functions. Law has two crucial functions. The first one is to reflect the society, right? Whatever the public wants and however we want to be treated. And the second equally important function is that of to mold the public as well, to mold the society as well. So I think what we need to now see is, because I think there's a great step in decolonizing, and I think for the first time in hundreds of years, the government has actually given the opportunity for everybody to be in a position where we can scrutinize the laws as citizens and treat them as our. So it's very important that we read them from cover to cover and see what is it that we feel about them and what we think about them. Because I think it's not only an opportunity to welcome the three laws, but also to celebrate them by engagement, participation, and by ensuring that, especially as lawyers, we are able to look at them in a concrete and a constructive manner, which ultimately helps in criminal justice. So that's all I had to say. With that, I pass it back to you, Soumya. Thanks very much.
Nikita, I will call you back in half an hour. Okay. Hello, sir. Am I audible?
Yes.
Thank you so much, sir, for sharing your profound knowledge and experience with us. Your commitment to making law accessible is truly inspiring. Now, if anyone has any questions, they can raise their hands, ask, or we will keep for the last. Now, moving forward, next we have the honor of hearing from Professor Dr. Kumar Askand Pandy, sir, on the third new law, Bharatiya Sakshi Adhiniyam. Sir is a founding faculty member of RMLNLU. Prior to joining RMLNLU, he was an assistant professor at West Bengal National University of Juridical Sciences, Kolkata, from 2004 to 2006. Having around 20 years of teaching experience, Sir's research interest lies in criminal law, criminology, victimology, comparative criminal justice law, law of evidence, media law, cyber law, research methodology, and juvenile justice. He is also guest faculty in several academic training institutes of national repute, including central universities, IITs, and NLUs. In 2015, he was invited by the Department of Women and Child Development, Government of Uttar Pradesh, to conduct the first ever social audit and rapid assessment of the childcare institutions in the state of Uttar Pradesh, and submitted 2 reports thereof. Since 2016, he is the project director of a major action research project sponsored by UNICEF under the title Strengthening Child Protection System in the State of Uttar Pradesh. Sir was also nominated as a member of the resource group constituted by the DWCD Government of Uttar Pradesh for framing the state rules under the JJ Act 2015, and in 2020-21, he was member of the expert committee for framing state rules under the PCMA. A prolific writer, Dr. Pandy sir has authored and revised 5 textbooks on criminal law, law of evidence, and juvenile justice, published by the leading Indian publishing house, Eastern Book Company. Dr. Pandey has been a member of several academic bodies, including the Academic Council of HBTU from 2009 to 2012 and the Academic Council of RMLNLU from 2021 till date. We are deeply honored by your presence today, sir. It is with great respect and anticipation that I now invite you to share your wisdom with us, sir.
Thank you, Soumya. Thank you for very elaborate and using very kind words introducing me. I would just quote Vishavjeet that I'm a student of law, like all of you. And that's the only identity that I want to retain with me. Having heard two erudite speakers on two criminal laws, one substantive and the other procedural, I was just wondering that how do I speak on the Bharatiya Sakshi Adhiniyam, which also got unfolded from the same date, that's July 1, 2024. And is there something which I can speak on for 20 odd minutes as far as the changes are concerned? Now, this I've said before, and I keep repeating from different platforms when I'm supposed to speak on any of these laws, that Bharatiya Sakshi Adhiniyam retains almost everything good that we had in the Indian Evidence Act of 1872. The Indian Evidence Act of 1872 that was comprised in 167 sections in all, spread over 11 chapters, has been almost copied in the Bharatiya Sakshi Adhiniyam of 2023. You have 170 sections spread over 12 chapters. The last chapter is a formal one declaring the repeal and also that how actions taken under the Indian Evidence Act would continue, of course, even after coming into force of Bharatiya Sakshi Adhiniyam. So if you see the changes, I believe that most of you must now have an access to either a digital copy or a physical copy of the Bharatiya Sakshi Adhiniyam, and for that matter, the other two laws that the other speakers talked about. You must have seen the tables listing the changes, the comparative table that section 302 is now section 103 of Bharatiya Nyaya Sanhita, section 304 capital A of IPC is section 106 of Bharatiya Nyaya Sanhita, or for that matter, section 154 of CRPC is now section 173 of Bharatiya Nagrik Suraksha Sanhita, this and that. Have you seen a comparative table comparing the changes in Bharatiya Sakshi Adhiniyam with its earlier avatar that Indian Evidence Act is? If you have seen, you would find that except rearranging sections to a certain extent, of course, not much has changed. But still, there are a few very, very significant changes with the far-reaching consequences, and certainly we need to wait for their practical use in the court proceedings before a final word on those changes comes out. Still, I would try to give my own opinion as to what I think would happen as far as those new changes are concerned. So before I formally begin with the talking about a few changes and then elaborating on those provisions which add or which delete or which reverse even the rule that existed right from 1872, let me apprise you of what we have added. We have added only two new provisions as far as the Indian Evidence Act is concerned. One is section 2, clause 2. Section 2 is, as you know, the definition clause. The definitions that you had in form of different paragraphs in section 3 of Indian Evidence Act are now in different clauses and have been arranged in an alphabetical order in section 2 itself. Section 2, Clause 1 has several sub-clauses, including definitions arranged in an alphabetical manner, which were in different paragraphs of Section 3. Section 2, Clause 2 is very, very significant. Section 2, Clause 2 says, and that's an addition, because you don't have any corresponding provision in the Indian Evidence Act of 1872, that words and expressions that have used in the Bharatiya Sakshya Adhiniyam, but not defined in the Bharatiya Sakshya Adhiniyam, but defined in either the Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, or the Information Technology Act of 2000, would be understood in the same sense in which they have been used in these three legislations. Now, reference to Information Technology Act is very, very important, because in the next 15 odd minutes that I'm left with, I'll be talking about the most important, most crucial, most critical changes that is going to affect the introduction, the question of admissibility, and the manner of making proof of what we call electronic records. While Advocate Vishavjeet was speaking on Bharatiya Nagrik Suraksha Sanhita, he mentioned that how now videography of almost every action of police, including searches and seizures, is a mandatory requirement under the Bharatiya Nagrik Suraksha Sanhita. He was also talking about recording of evidence, and he said that now recording of evidence could be through audio visual means. Now that takes us to two very, very important changes as far as the definition of the word document and the definition of the word evidence in Bharatiya Sakshya Adhiniyam is concerned. As I already said that Section 2 of Bharatiya Sakshya Adhiniyam is the definition clause, where you would find almost every definition, I must say, almost every definition, because a few definitions have been dropped. As you know that there is no definition of India, and for obvious reasons, of course. Another very important thing, before I tell you that how the definition of evidence and also the definition of a document explicitly recognizes the manner in which evidence may also be given using audio visual means, and then bringing the digital documents on a par with the physical or paper documents. I don't know how many of you noticed, but neither the Bharatiya Nyaya Sanhita nor Bharatiya Nagrik Suraksha Sanhita, and of course Bharatiya Sakshya Adhiniyam as well, they do not talk about the extent of operation. Typically, every legislation, even legislations that have been passed by the same political dispensation, they would have this opening section prescribing the territorial extent of that particular legislation in this formal phrase that this act may be called this, and it extends to the whole of India. The words except the state of Jammu and Kashmir were omitted in 2019 for reasons that are too familiar. I need not repeat. BNS doesn't specify its extent of operation. Bharatiya Nagrik Suraksha Sanhita also doesn't specify its extent of operation. And as I said that even in Bharatiya Sakshya Adhiniyam, there is no mention of its extent of operation. That omission is deliberate. That omission is deliberate because there is a great emphasis not only in the Bharatiya Nagrik Suraksha Sanhita, but also in Bharatiya Sakshya Adhiniyam on electronic records and also on recording of evidence using audio visual means. So someone who is sitting in United States of America or in some other foreign country testifying, would be using these means, and that testimony would be evidence as far as for the purpose of Bharatiya Sakshya Adhiniyam. So in order to obviate any kind of a controversy that might arise in future as far as recognition or admissibility of those evidences under the Bharatiya Sakshya Adhiniyam is concerned, this omission is very significant, and this omission is very, very important and deliberately done. So I was talking about the changes that have been brought in, key changes. And I said that only 2 sections have been added, 2 provisions have been added. Section 2, Clause 2, words and expressions, not used in BSA, but used in 3 other provisions, would be understood in the same manner. Then Section 61. Section 61 does not prescribe any rule, it only states the obvious. If you read Section 61 says that the digital records or electronic records, they would have the same legal validity as their paper counterparts or their physical counterparts. Then if you see how many provisions and what provisions have been dropped, even then you would find that only a handful of them have been dropped. For example, in the definition clause, you don't have the definition of India. Section 22, capital A, which was not the part of the original Indian Evidence Act, but was only added in 2000 after IT Act of 2000 came into being, which specified the rule when oral admissions as to the contents of electronic records are relevant. That has been dropped again for obvious reasons. Section 82, which was in the original Indian Evidence Act, which talked about presumption as to the document admissible in England without proof of seal or signature. Certainly, Indian Evidence Act of 1872 was a law that was administered in British India. So certainly there were many occasions when a certain document that would be produced would be sought to be admitted or presented in English court. So this section 82 had outlived its utility. Section 88 has been dropped. This also had become obsolete and archaic. Section 113 has been completely dropped. Section 166 has been dropped, which provided for and talked about the power of jury or assessors to put questions. You are aware that we abolished trial by jury or the jury system of trial way back immediately after that famous, if anyone could tell which famous case I'm talking about, after which this trial by jury was abolished.
Nanavati case.
Nanavati case. That's a fantastic, correct answer. So this section 166 had also become obsolete. Barring these provisions, you would find that only cosmetic changes are there in other provisions. What cosmetic changes I'm talking about? Words like vakils, barristers, attorneys, pleader, etc. that you would find in several provisions of Indian Evidence Act. For example, section 128 of Indian Evidence Act. The corresponding provision in Bharatiya Sakshya Adhiniyam is section 133. So in section 128 of Indian Evidence Act, you would have a reference to barristers, attorneys, pleaders, vakils, which again have become obsolete after the Advocates Act came into being. And everyone who practices law in the Indian court would be referred to as an advocate. He has to earn that qualification. He has to also, Vishavjeet was talking about bar examination and all. So that word has been used wherever the words barrister, attorney, pleader or vakils were used. Then references to British Parliament and a few other provisions which had no application anymore to the sovereign India that came into being in 1947, or after coming into force of the constitution, they have been omitted. Except those, we have only rearranged the sections. So you have the same principles which were prescribed by Stephen in the chapter on relevancy. You have the same rules which were prescribed by the Stephen on the manner in which proof would be made of content of a document. You have almost the same definition of so many words which have been used in Bharatiya Sakshya Adhiniyam without any even cosmetic change. For example, the definition of fact, the definition of fact in issue, these definitions which are very crucial, which are very critical, which are very, very important in order to grasp in a holistic manner the law of evidence, they have been retained with the same illustrations. This I must say. So what are the most significant changes? If I could just tell you what most significant changes are, as I already said that the definition of document in section 2(1)(d) now specifically includes electronic and digital records. And a new illustration has also been added to exemplify this edition. Allow me to quote that illustration. I won't be reading the definition of a document that you would find in section 2(1)(d), but reading that illustration would explain that how significant this edition has been. The illustration 6 reads, and I quote, "An electronic record on emails, server logs, documents on computers, laptops or smartphones, messages, websites, locational evidence, and voicemail messages stored on digital device are documents." So this is only stating the obvious. Even before July 1, 2024, the courts would be considering all these electronic records as documents. But this inclusion in the definition and this illustration is very, very significant, leaving no doubt whatsoever remained that these electronic records are also documents. Then the definition of evidence in section 2(1)(e) of Bharatiya Nyaya Sanhita now includes statements given electronically. So whether the statement is given orally while the person giving testimony is present physically in the court, or whether it is being given electronically from within India or beyond India, that would also come within the meaning of what we call oral testimony or oral evidence. I'd also told you that law remains intact, the principles remain intact. The only changes that have been brought in with the view to make law of evidence keep pace with the advancement in technology and the growing use of ICT in our daily life and in transacting business. So you'd find that sections 24, 28, and 29 of Indian Evidence Act that talked about extrajudicial confessions, they have now been clubbed together in section 22 with a very minor change. That minor change is that the provision which declared that a confession caused by inducement, threat, or promise when irrelevant in criminal proceedings now adds the word coercion. So now you have this provision read like this: confession caused by inducement, threat, coercion, or promise when relevant in when irrelevant, I'm sorry, in criminal criminal proceedings. This again states the obvious. If a confession that has been caused by inducement, certainly a confession that has been caused by coercion would also be irrelevant. Then you, especially those of you who have had some background in law of evidence, those who have studied law of evidence formally, informally, they might be knowing about an academic debate. That academic debate even went to the corridors of the Supreme Court, and the Supreme Court had opined on that whether Section 27 of Indian Evidence Act is an exception or proviso to Section 26 of Indian Evidence Act, or even Section 24, 25, and 26 are governed by it. I hope you are getting this issue. There was this debate, academic, more academic in nature, on this issue, that whether Section 27 of Indian Evidence Act, Section 27 talks about how much of a confessional statement is admissible if that statement leads to discovery of a new fact. You know that provision. I'm not here to teach you law of evidence, but only to tell you about the key changes that have been brought in as far as Bharatiya Sakshya Adhiniyam is concerned. Because Section 27 of Indian Evidence Act is unusually worded. It starts with provided that, and often provisos are an integral part of a certain provision. So this question now seems to be settled because Section 24, 25, 26, and 27, they have been clubbed together in Section 23 itself, 23. And Section 27 of Indian Evidence Act is now a proviso to Section 23, Clause 2. Similarly, Section 24 of Bharatiya Sakshya Adhiniyam, it corresponds to Section 30 of Indian Evidence Act, that talks about testimony of an accomplice that implicates the co-accused as well, when the two accused persons are facing a joint trial or being tried jointly. An explanation has been added, which was not part of the scheme under the Indian Evidence Act, which says that a person being tried jointly in absentia would be deemed to be tried jointly for the purpose of Section 24 of Indian law on evidence, the latest law on evidence, that is Bharatiya Sakshya Adhiniyam. Let me explain this little more. You are aware that Bharatiya Nagrik Suraksha Sanhita has brought in this concept of trial in absentia. You may refer to Section 356 of Bharatiya Nagrik Suraksha Sanhita. Trial in absentia is a new kind of trial, of course, that Indian courts would find difficult to cope with. This is what I believe. Now, Section 24 of Bharatiya Sakshya Adhiniyam, which corresponds with Section 30, talking about joint trial, refers to that trial in absentia, and declares that if two persons are being jointly tried, even if one is not physically present and is being tried in absentia, Section 24 would have an application with full force and full vigor. So what are the other significant changes? The other significant changes include a complete reversal of rule as far as the use of testimony of an accomplice is concerned. Can you recall the rule embodied in section 133 of Indian Evidence Act? Anyone who could recall a rule embodied in section 133 of Indian Evidence Act regarding testimony of an accomplice? The rule provided, is anyone going to answer that question? This is not to, of course, test your knowledge, of course. If you have the Bear Act ready with you, digital or physical copy,
So
of course. You can.
it was regarding that an accomplice can be a pure like a witness of the crime
Mhm.
and provide like they can give their statement. They
Uh-huh.
can be a they can give their statement about that.
Partially correct, I must say.
Mhm.
Partially correct, I must say. In fact, section 133 has been retained, but the rule has been reversed. That is the only instance. That is the only instance where the entire rule has been reversed. The original rule, as conceived and included in the Bharatiya law, I'm using that Bharatiya law to mean the law of 1872. It provided that an accomplice is a competent witness, no doubt about it. And further declared that a conviction is not illegal merely because it proceeds on an uncorroborated testimony of an accomplice. Please listen to this carefully. The earlier rule was that an accomplice is a competent witness and a conviction is not illegal merely because it proceeds on uncorroborated testimony of an accomplice. Now, certainly no one can be convicted merely because an accomplice has testified against him or her. So this rule of section 133 of Indian Evidence Act was significant because it said that it's not illegal to convict. If it proceeds, it may proceed. But certainly that's not the end. You have to proceed and you have to reach a logical conclusion where the evidence in the opinion of the court are convincingly qualitatively sufficient in order to record a conviction. What is the rule now? Section 128 of Bharatiya Sakshya Adhiniyam declares, one, that an accomplice is a competent witness. It further declares, and listen to this carefully, that a conviction is not illegal merely because it proceeds on a corroborated testimony of an accomplice. So earlier the law was very harsh on the accused person. A conviction may have proceeded on even an uncorroborated testimony of an accomplice. But from July 1, 2024, a conviction shall not be illegal merely because it proceeds on a corroborated testimony. So if the courts have to proceed with or to use this testimony of an accomplice as the starting point to proceed against the accused, they can only proceed when the testimony of the accomplice is corroborated in material particulars, I must say. If there is a testimony of an accomplice, but that remains uncorroborated, certainly conviction cannot proceed on such a testimony, because the law now declares such a conviction not a legal conviction, meaning thereby it's not a legally tenable conviction. As I already said that even before the advent of Bharatiya Sakshya Adhiniyam, there was no doubt that electronic documents or digital documents are documents for the purpose of Indian Evidence Act. Emphatic recognition came in form of section 61, and then again the change in the concept of primary evidence that you would find in section 57 of Bharatiya Sakshya Adhiniyam, which includes 4 new explanations. Section 57 of Bharatiya Sakshya Adhiniyam, which talks about primary evidence, includes 4 new explanations. All those 4 new explanations explain that what electronic records, in what circumstances would be primary evidence. Now, why these why these explanations are important? Because if the electronic record is not a primary evidence, rather it's only a secondary evidence, there is a further formality to be completed, and that formality was to produce a certificate. Earlier it was section 65 capital B of Indian Evidence Act. Many of you are aware that it was only in 2014 that the law got settled, that whether section 65B certificate is a mandatory certificate or not. In PV Anwar versus PK Bashir case, a 3 judges bench of the Supreme Court declared that section 65 capital B must be complied with before the courts consider or take on record a secondary evidence of an electronic or digital record. The same was again doubted in Shafi Muhammad versus State of Himachal Pradesh case, you may be aware, and was finally settled in probably Arjun Pandit Rao, a case which reiterated the views that were taken by the Supreme Court in its earlier judgment of 2014. So section 65B's counterpart is section 63. Section 65B and section 63, if compared, would reveal only one difference, one significant difference. Certainly, there are certain other differences in language, but those differences are only cosmetic. They are not going to change the rule. They are not going to change the jurisprudence, except the requirement that under the earlier regimen governed by section 65 capital B, a certificate was no doubt required, but there was no template, there was no format of that particular certificate. And if you read that Anwar PV versus PK Bashir judgment, the Supreme Court said that the person in whose possession at the relevant time that communication device or computer was, is to merely state that that communication device or computer was working properly at the time the relevant data was fed and the output was taken. That certificate could have been issued even by a private individual. Suppose I have a certain video recording in my mobile phone or in my DVR, and I need to rely in a civil or criminal proceeding on those recordings. I would be the one who would be giving that certificate. I may be a layman, certainly, but I would be the one who would be required to give the certificate. Now that has drastically been changed. So what that changes, that section 63 also talks about the requirement, mandatory requirement of a certificate accompanying secondary evidence of an electronic record. But now in the schedule that has been appended to Bharatiya Sakshya Adhiniyam, there is a template, and that template is in 2 forms, 2 parts, part A and part B. Part A has to be filled by the person in whose possession that computer or communication device was at the relevant time, and part B has to be produced by an expert. Now, if you compare the columns in part A with the columns in part B, you'd find that except a few personal informations, rest of the informations are common. For example, in part A, that is to be filled by anyone in whose possession that communication device was, is to also provide information regarding hash value of the document. The expert would also be providing information regarding the hash value. Though it's true that the information is to be provided to the best of one's knowledge, but certainly some greater know-how is required, even on the part of a layman who seeks to produce this certificate along with an electronic evidence that he seeks to rely on. And that's going to sort of create a lot of difficulties as far as admissibility of secondary evidence of an electronic record is concerned. Another important question: who would be an expert for the purpose of Part B of this certificate? Now, as you are aware, that Indian Evidence Act in Section 45 as well as in Section 45 capital A, which was more specific to examiner of an electronic record or expert in the domain of ICT and this cyberspace is concerned. Section 45, 45A, they have been consolidated and clubbed together in Section 39 and define an expert in almost the same manner in which expert has been defined in Section 45 of Indian Evidence Act, except that the words or any other field, one who has had sufficient exposure, experience, has acquired special skills in the field of art, science, foreign law, or any other field that has been included. Then you have Section 79 capital A of IT Act of 2000 as well, which talks about certain institutions being notified as examiners of electronic record. Why would one be examining electronic record? One would be examining electronic record only in order to compare the hash value, which authenticates that yes, the electronic record that is being produced is the same that was generated in the first place. That can only be done by comparing the hash value. There are other modes and methods as well, but the most popular and the easiest one is to compare the hash value. Hash value can be changed. Hash value can be manipulated. I agree. I understand. But then that's one preferred way of comparing the two documents, which it is claimed are one and same, one original, the other a copy of it, digital copy of it. Both must be in digital format. So what I believe is that anyone who has acquired some special skill in comparing two documents, comparing the hash value of the two documents, or using some other scientific method of comparing the two documents, concluding that the two documents are same or different, would be an expert for the purpose of Section 63 of Indian law of today, that is Bharatiya Saksha Adhiniyam. Another area of concern, I'll be concluding in 2 minutes. Another area of concern that I must flag is that there is no specific provision which all of us were anticipating and waiting, especially post K.S. Puttaswamy judgment. K.S. Puttaswamy judgment is an important milestone in evolution of several fundamental rights, including the right to privacy in this country. So we were anticipating, everyone was anticipating with bated breath, with fingers crossed, that the Bharatiya Saksha Adhiniyam would declare that illegally obtained evidence is not admissible. But there is nothing as far as Bharatiya Saksha Adhiniyam is concerned. There is nothing in Bharatiya Saksha Adhiniyam that even obliquely touches on this issue. And I believe that the jurisprudence that has emerged in the last so many years through the pronouncements of the Supreme Court, where the Supreme Court said that even if an evidence has been obtained illegally, the only consideration is that whether it has been declared to be admissible in accordance with the the theory of relevancy or not. And that's the only criteria that we are going to employ. Many of you might be aware that there was this 2019 judgment in which it was contended by one of the parties that the evidence that they are relying on is based on a document that they had stolen from our custody. And the Supreme Court was called upon to adjudicate on the admissibility of such documents. It's Birla Corporation versus Advents Investment and Holdings Limited, 2019 judgment, where the Supreme Court said that this act was not theft. I don't agree with that opinion, but that's another story altogether. Even if that was theft, the document, if relevant, contents, if relevant, would be admissible. So this is what I had to say as far as key changes in Bharatiya Saksh Adhiniyam is concerned. The few other changes which are not that significant, for example, no court can ask what transpired between the President and the Council of Ministers, of course, anymore. No communication between the President and the Council of Ministers can be asked for in any court proceeding. This is what Section 165 of Bharatiya Saksh Adhiniyam talks about. This is also a new exclusion. As I said, that other rules have retained with the very cosmetic and very minor changes, which were necessitated because certain archive words and references to those obsolete legislations in Section 1 itself were made. They have all been sort of dropped. So that's it from my side, and thank you for very patient listening. Thank you, Soumya.
Thank you, sir. Thank you, sir, for your insightful and impactful presentation. Your work in strengthening child protection and justice system is truly invaluable. Now, with this, we mark the end of sir's presentation. Now, those participants who have their queries could raise their hands, unmute themselves, and ask questions. If anyone has any query, they could raise their hands. So, one question from my side, sir, regarding this, as you just did, like the judiciary will not be able to question the discussions between the President and the Council of the Ministers. So, won't it affect our right to information? And as we go and just file a RTI that we need to seek some information regarding what happened.
That's very interesting question.
Yes, sir.
That's very interesting question. I'll be very brief in answering your question. Don't we have Official Secrets Act existing at the same time when we have
Yes, sir. Yes, sir.
Right Information Act?
Yes.
Isn't that a conundrum? If that's a conundrum, I've already answered your question. Even if that's not a conundrum.
Yes, sir.
And you believe that both the legislations, one favoring secrecy, opaqueness, the other trying to usher in sunshine, openness, transparency. If both have a space, you can rationalize the reasons why both can exist together and why both should exist together. There may be certain communication between the President and the Council of Ministers, disclosure of which would jeopardize the national interest, maybe. And vested interest may approach the court, requesting the court to issue directions or arguing that they want to rely on a certain communication that has taken place for vested interest. So certainly that is a welcome exclusion to my understanding. And the right to information, like every other right, even if that is also included in, and indeed that is included in the concept of fundamental right has the obvious exceptions that you apply. So none of the rights are absolute. Right to information
Yes, sir.
included. That's it.
Yes.
Yeah.
So one more from my side for this particular law. How does this new law enhance the admissibility of the circumstantial evidence? If we are considering the circumstantial evidence, how does this new law impact the admissibility of the circumstantial evidence?
It doesn't in any manner. In fact, the same rules, punch shield rule. I think you are aware.
Yes.
Punch shield rule. There are 5 conditions for admissibility of circumstantial evidence, in the sense that reaching to a conclusion of guilt based on circumstantial evidence. Circumstantial evidence is admissible. Circumstantial evidence was admissible under the Indian Evidence Act. Circumstantial evidence, if that falls within the rules of relevancy from section 5 to 55 in Indian Evidence Act, and probably it starts from section 3 to 50 of Bharatiya Sakshya Niyam. Certainly that would be admissible. So what do you mean by circumstantial evidence? Suppose I was at the scene of crime, all right, and I'm produced as a witness. And when I'm asked that what did I see, and I tell that I saw the accused running away. When I'm asked that did I see the accused stabbing the victim, and I say that no, I did not, because I in fact did not. I only saw the accused running away. Accused running away being seen by eyewitness, that eyewitness would be testifying to a circumstance which is incriminating. What is that circumstance? The circumstance is that the accused was present at the crime scene and was seen by people running away in a suspicious manner. Is only a circumstance. Can one be held guilty based on this testimony? केवल इसी टेस्टिमनी पर कि मैंने अक्यूज्ड को भागते हुए देखा था. ऐसे बहुत सारे लोग होंगे ना जो उसको चाकू घोंपते हुए भी देखेंगे, जो उसको भागते हुए देखेंगे. जो चाकू घोंपते हुए देख रहा है, that's a direct evidence. Direct evidence. That's why in many standard textbooks you would find a discussion very elaborate, including in Vepa Sarthi's book that I have had the honor of revising for the past 2 editions, that how a direct evidence is compared with indirect evidence, and how direct evidence is compared with the circumstantial evidence. So X seeing Y stabbing Z is direct evidence. X seeing Y running away after having stabbed Z is a circumstantial evidence. So circumstantial evidence, the way it was admissible in the Indian Evidence Act, I already, probably I repeated this, that none of the rules have changed except the rule regarding testimony of an accomplice in section 128 of Bharatiya Sakshya Niyam. I hope I answered your question.
Yes, sir. Surely, sir. Thank you so much, sir, for answering my queries. Now, if the participants wish to question Vishavjeet sir and Prachi ma'am, they can raise their hands. I hope sir is able to hear me. Vishavjeet sir and Prachi ma'am, are you there? Okay, sir.
I can hear you, Soumya.
Okay, sir. So, if the participants are not, I have a lot of queries from my side to ask. Let's get with that Bharatiya Nagrik Suraksha Samhita. So from my side, in what ways does this new security law address the balance between state surveillance and individual privacy rights?
So that's a very good question, the answer to which can only be given in piecemeal, because I think this is one small part in the bigger, system of law, and also in the bigger sort of justice delivery system. I think one of the things that we need to be careful about is how is the data that is being collected. So for instance, during search and seizure, how is it that we are going to be using that data? Where are we storing that data? Because in light of this, there's also the data protection which is impending, right? Then you've got the right to privacy, which also already exists. So I think you'll have to be balancing all these aspects of the law to make sure that it delivers on security. And as Professor Pandey said, none of the rights, as we understand, are absolute. So there are those certain levels. So where we draw the line, I think, will be an interesting question to answer and to also see. But as of now, I think it doesn't change anything too significantly in terms of rights towards privacy.
I bit of it understood. Somewhat I got it. If anyone, now moving forward, if anyone wants to ask questions to Prachi ma'am, are you there? If you are able to hear me, please.
Yes, I'm able to hear you, Soumya.
Okay, ma'am. Just to ask a question, ma'am, like if we go for Bharatiya Nyaya Sanhita, like it's like if we are to analyze the impact of Bharatiya Nyaya Sanhita on the interplay between like statutory law and judicial precedents, which were being followed from like a long time, what will this new law impact on them?
That's a very interesting question because, of course, we have not discussed it. But the judicial precedents which are set, they will definitely stay in play for a lot of things. And we have seen that a lot of changes in the law, I won't say a lot of changes, but if you say at least 30 to 40% changes in the law has happened based upon the judicial precedents which are there. So that change has happened, but the precedents which are already there, I assume that they will be kept in my consideration because see, either something which has completely been deleted, which is no longer part of the legislation, that will not be admitted, but which is part of the legislation which has just changed its section number or changed its format a little bit, where the punitive part has increased or certain other changes have happened, a little transformation has happened, there the precedent will be in play. They will borrow from the previous judgments, but depending upon the situation in the current law. But yeah, that's a very interesting question you have asked, and let's see how the judiciary deals with it. But this is how usually it is done, and I'm hoping it continues like this. But definitely, as we know, it depends upon judges to judges.
Thank you, ma'am. Thank you. I guess sir has to say something.
Just to add to what Advocate Prachi said, in fact, I would refer to a 1955 judgment of the Supreme Court, Bengal Immunity Company versus the State of Bihar. Bengal Immunity Company versus State of Bihar has answered this question that you just asked. If a provision has been repealed and then reenacted verbatim, the interpretation put on that particular provision by the constitutional courts, Supreme Court, would remain binding, would remain the interpretation to be followed. The reason that has been cited by the Supreme Court in Bengal Immunity Company case for this inference is that it's presumed that the legislature knew about those interpretations, and despite knowing those interpretations, retained the provision verbatim. So certainly, Advocate Prachi is correct when she says that they would remain relevant. But in case there is a change in the language, there is a change in the rule, there is change in the law, even if that change is very slight, very modest, very small, insignificant, it's to be seen that how the courts are going to sort of interpret the new provision, of course. So,
yes, sir. Surely, sir. Thank you so much, esteemed speaker, for answering my queries and clearing the doubts of everyone present here. Now, marking the end of the session, with your due permission, I will proceed with the vote of thanks. On behalf of everyone present here, I extend a heartfelt gratitude to our esteemed speaker, Prachi ma'am, Vishavjeet sir, Dr. Pandey sir, for sharing such valuable insights during this enlightening online session. Your expertise and clarity have truly enriched our understanding. We are grateful for your time, dedication, and the effort you have made today, sir, ma'am. Thank you once again for an outstanding presentation. Thank you.
I must add one thing that it's very rare to see more than 100 participants towards the end of this.
Right.
This big thumbs up to the team, of course. This is wonderful.
Sir,
On a Sunday
it was
evening,
a very needed topic to be
having
discussed.
100 plus participants when you are winding this up is truly amazing. Amazing. Congratulations, all of you.
Thank you so much, sir.
And it was a great learning, Vishavjeet and Prachi, both. Thank you very much.
Thank you, sir.
Swami, I hope you have taken the attendance.
Sir, I have yet to take the attendance of the participants. I am done with the other things yet.
All
The
right.
participants
So
are
then-
yet to remain. Sir, ma'am, thank you so much.
Thanks very much, Soumya. Have a good
Thank you.
evening.
Have a good evening, sir.
Participants are requested to stay till the attendance has been taken. The participants who are leaving the meeting would not be getting the attendance, so kindly stay.